Hello, everyone, and welcome to our webinar on preparing your business for success in 2024. My name is Taylor, and I'm an associate in LegalVision's commercial team. I'm joined today by my colleague Georgina, who is LegalVision's general manager and practice group leader of our corporate team. Before we begin, a quick couple of housekeeping items. You'll all receive the recording and slides of this webinar in your email. Throughout the webinar, feel free to submit questions in the chat box and we'll be sure to answer them at the end. And please feel free to complete the feedback survey after the webinar. That's really helpful for us. Also, all attendees are eligible to receive a free consultation with us to discuss how we can help you with your contracts or any of your legal needs. To request this free consultation, just provide us with your contact details in the survey that appears at the end of the webinar. So today we will be discussing how to prepare your business for success. This is particularly in relation to your business structure, protecting your intellectual property, your data and privacy law obligations, your customer contracts, your third-party contracts, and your employment relationships. As I said before, at the end of the webinar, we will be answering some questions, so feel free to submit those throughout. And now I will hand over to Georgina to speak about your business structure.
Thanks, Taylor. And it's quite a hefty list of topics that we're looking to cover today. So we will do our best to do a good high-level overview of everything, and then obviously answer your specific questions at the end. So the first point that we are discussing is around your business structure. So this really is, the foundation of your success, and the right structure can obviously be really dependent on your particular business, what stage it's at, and the industry in which it operates, and even your personal situation if you are sitting there as a founder. And of course, it's always key to remember that what was appropriate for you on day one might no longer be appropriate as you grow and scale your business. So we really encourage our clients at LegalVision to continue to assess your structure and work out whether how your business is currently structured is appropriate, taking into account the current growth and stage that you're at, as well as obviously your plans into 2024 and beyond. Now, of course, having the right structure in place as early as possible is ideal, albeit we do recognise that that's not always realistic, because restructuring can be quite an involved process, especially when you do have a broad shareholder base. So just something to keep in mind. Now, getting it right early, it's not only incredibly helpful from a process perspective, but it can be hugely beneficial as well when you're preparing for a capital raise or an exit event even. So in terms of the specific questions we recommend you should be asking yourself, we suggest that you're considering the following points as you come into 2024. So the first one being, has your business grown in size and revenue, or do you expect a significant growth this year? So any significant increase in size typically means there's more contracts and more potential liabilities in your business. If you're a sole trader or you're in a partnership, you might need to consider whether these changes to your business now expose you to more personal risk. And if that's the case, then you might want to be looking into that restructuring route and looking into maybe potentially setting up a limited liability company to reduce that personal risk that you're now exposed to. When also you are seeing increased revenue, you should also be considering at that point whether your personal tax rate will be higher than the company tax rate, which is obviously currently 28%. So obviously each of these changes will impact potentially how you are structuring your business and whether your current business structure is appropriate. Now, the next question we've got there is, has your business generated or will it generate any valuable IP? So again, that's a good time if it has to ask whether a dual company structure might now be appropriate. In that dual company structure, typically what we do is we put the key assets shifted into and held in a new holding company, while all your contracts and therefore all your trading liabilities are entered into by the operating company where most of your risk lies. Now, as your business grows, you may also choose to diversify and have separate companies for each arm of the business's operations, which further limits, overall liability of each company, further protects you and your key assets. The next question then is, if you're a company, have you brought on more shareholders? A really simple question, but what it does cause you to ask is my shareholders agreement, has it been prepared from the outset, and also is it accurate, is it up to date, is it a fair reflection of the commercial agreement and understanding between each of the parties that are involved. And then the more sort of process driven side of that is, has the New Zealand Companies Office been updated to reflect those new shareholders as well? And then the final question there is, are your business licenses correct and are they up to date? So this will vary industry by industry, but it's just a timely reminder at the start of the year to check and ensure that they're renewed where you do have them in place, check that they're still accurate in terms of the information provided. Now, I know that I've touched a lot on the potential restructuring option. Just keep in mind there that in that situation, if you do decide to go down that route, typically your lawyer will work with you alongside your accountant to often help determine what the most sort of tax efficient structure is for you. And that will help inform, but not necessarily dictate where you land in terms of what the right legal structure is for you. Now, LegalVision does have a number of external tax and accounting providers who we work with regularly on that front, and we're obviously happy to connect you if you don't already have that support in place. And we've also got a lot of freely available content talking through those business structuring kind of options that we'd be happy to share with anyone that's attending today if you think that that might be something you need to consider. So over to you, Tayler, for intellectual property.
Thank you, Georgina. So obviously, as you mentioned, businesses tend to evolve and grow over time. And throughout that process, it is key to regularly ensure that your business's intellectual property is adequately protected. So first off, with your current IP, this may include things like your branding, such as your business name and logo. And these are assets which are worthwhile protecting for your business, such as via a trademark. The trademark registration process can be a long process from the date on which you lodge your application, and so it's best to start this process early. You should also do regular checks to ensure that your brands and product lines are cleared for use to avoid infringing any other third-party rights. And while IP registration, such as trademarks and patents, are important, so too is the contractual side of IP ownership. In terms of your future IP and your contracts, as you expand your brand and perhaps add additional trademarks, slogans, business names, or trading names, it's important to trademark these as well. If you're also planning on expanding overseas, you should consider whether you require trademark protection in those overseas jurisdictions as well. When you enter into a contract with someone else, depending on the nature of the goods and services to be provided, there may be new intellectual property created when the parties perform their obligations under that contract. Your contract should therefore contain clauses which detail which party owns the intellectual property that is created or used after the contract is entered into. In this regard, a contract should consider ownership rights in respect of any intellectual property rights which are owned prior to the contract being signed, any intellectual property that is created or developed under or throughout the contract, and any improvements made to a party's pre-existing intellectual property rights or to the intellectual property created or developed under the contract. You should also consider whether or not you will need a license to use the other party's IP and whether it would be a good idea to give the other party a license to use your IP. For example, if you need to use their IP to provide your services, this should be included within your contract. If you are going to be giving the other parties deliverables, which will include your IP, the other party will also need a license so that they can use those deliverables. The scope of the license can vary, and it's very important, including whether it's revocable, transferable, sub-licensable, royalty-free, only to be used during the term of the agreement or ongoing, and the purpose for what the IP can be used for. This is where ongoing monitoring becomes important. So it's important to regularly check whether other businesses are encroaching on your registered trademarks, and if so, take legal action, such as sending a cease and desist letter to enforce your rights to exclusively use that trademark. LegalVision can also assist you with tracking your trademarks. And now I'll hand over to George to talk about data and privacy.
Thanks, Taylor. So, look, data and privacy are always going to be important and also ongoing considerations for your business. So, again, another good thing to revisit at the start of the year. So, any business that is collecting your personal information is required to comply with the Privacy Act. And the purpose of the Privacy Act is basically to govern how the businesses are collecting the information, how they're using it and storing it. Now, when we talk about personal information, we're talking about information about an identifiable individual, so such as their name, their email address, their photo ID, things like that. Now, if you're collecting that information, you need to have a privacy policy in place, which is setting out certain critical matters, such as what's the kind of personal information that you're collecting, how are you collecting it, and for what purpose are you collecting it, if it's going to be disclosed overseas, and also how you will deal with any complaints, among other things. So the policy should always be reviewed regularly, and it needs to be up to date with your current privacy practices. And we typically recommend to our clients that you're reviewing your privacy policy every year. So the idea here is that you're considering it a living document rather than a document that you can set and forget about. That leads us then on to deciding whether, questioning whether you're prepared for a notifiable privacy breach. So if you suffer a privacy breach that either has caused or it's likely to cause anyone serious harm, then you need to notify the Privacy Commissioner and as well as any affected people as soon as you can. So examples of what serious harm means would include things like physical harm or intimidation, financial fraud, including unauthorized credit card transactions or credit fraud, family violence, and psychological or emotional harm. Now, notifications can be made via the Notify Us function on the Privacy Commissioner's website. We do recommend having a privacy breach response plan prepared. And that's basically an internal policy that sets out the process that your employees should take if you do experience a data breach and who's responsible for any escalations in that process. So really critical document, internal document to have. And we also recommend, obviously, making sure that you have adequate software and security in place to make sure that any personal information that you hold is adequately stored and protected to prevent against these situations. So over to you, Taylor, on customer contracts.
Thanks, Georgina. So it is a good idea to have your customer contracts or any customer terms and conditions that you're using reviewed regularly to ensure that they are compliant with any recent law changes. The main pieces of legislation which protect consumers in New Zealand are the Consumer Guarantees Act 1993 and the Fair Trading Act 1986. There is currently an amendment to the Fair Trading Act before Parliament, which is at the select committee stage. And if this amendment is passed into law, it will require any businesses who sell gift cards to ensure that they have an expiry date of not less than 3 years from the date of sale. If you sell gift cards, you'll need to ensure you update your terms and conditions and gift card issuing process to ensure compliance with this requirement. In terms of your third-party contracts, it's also important to consider whether you have the right contracts in place for your clients and your team. If you are a distributor and if you sell online, theoretically you could sell all around the world. However, if you are breaking into overseas markets and you feel this is a challenge to you, you may choose to set up distribution channels overseas with distributors who know their market and have a good customer relationships in those places. If you've worked out that you have enough products to export and supply to the markets into which you are expanding, and you've set up arrangements with those distributors in the countries in which you plan to sell, you'll need a really solid distribution agreement outlining the rights and responsibilities of you and your distributor. In terms of general supply, Service agreements should be in place with individuals or businesses who supply goods or services to your business. Do you engage manufacturers or to manufacture goods or services for you? If so, make sure you have an agreement in place describing the manufacturer's obligations, including shipping and delivery, confidentiality requirements, and an obligation to fix defective products. If you are engaging a development firm to build an app for you or you're updating your website, you also want to ensure the agreement has an acceptance testing regime, which allows you to accept or reject the deliverables, milestones, and an IP ownership clauses are going to be really important. So you should make sure that they're clearly spelled out in the agreement. In terms of software, you're undoubtedly going to be using a variety of software when running your business, including client management systems, marketing providers, team collaboration and communication platforms, payroll software, and third-party payment processors. Or you may have a software offering yourself. Each of these providers will have a software as a service, otherwise known as a SaaS agreement, or terms and conditions for you to accept and potentially negotiate. We would certainly recommend you have a lawyer review these so that if you're unaware of any potentially unfavorable terms, for instance, if you're handing over client data to these providers, you can ensure that they're going to keep this information confidential and comply with relevant privacy laws. Depending on who the supplier is, i.e., are they a big company with their own contract, or are you going to be able to enter into the agreement using your own contract? You may need contracts drafted or reviewed, and LegalVision can assist with all of this. I'll now hand over to Georgina to discuss employment relationships.
Right. And so with sort of this is the, I guess, final kind of substantive part of the session today, but we're talking really briefly here around your employment relations. So in terms of setting yourself up for success in 2024, it's really important, particularly this year, to be across all the recent changes that have been happening to New Zealand employment law. Really important to be across them, obviously, so that you can ensure compliance. This is typically a very busy practice area at LegalVision for exactly these reasons, is protecting against non-compliance, and then obviously dealing with the issues that inevitably crop up when there are issues of non-compliance. So in terms of those recent changes, which we'll obviously just briefly touch on here, but it's for the purposes of triggering some thought at your end, the changes that we've seen recently is the reintroduction of 90-day trial periods, which can now be used by all employers, provided certain criteria are met. Next, there's new requirements in the Worker Protection Act, which are aimed at preventing migrant exploitation. There's been a repeal of the Fair Pay Agreement legislation. And then finally, there's been an extension to the time available to employees to raise a personal grievance when it's in regards to sexual harassment. And that's increased the period to raise the grievance from 90 days to 12 months, so a significant extension there. Now, while we won't go into those changes in any detail, because obviously it may not be relevant to everyone attending today, it is worth flagging that if you do have employees in your business and you are interested in learning a bit more about them, these changes and how they might impact you, our employment team is running a free webinar specifically on those changes in March, which dives into all the detail that you're going to need. So I really do recommend that you consider attending that, or at least registering so that you can watch the recording afterwards. Now, each of those changes are a really great opportunity to revisit your business's employment documentation. So, while you might not be able to go through all the existing agreements and well, you will need to anyway, but in terms of setting yourself up with good template documentation going forwards, it's a great chance to look at the template contractor agreements that you have in place, template employment agreements, your employment policies, and making sure that you do a complete refresh of those to ensure that they are up to date with those recent law changes. Now, from a corporate lawyer's perspective, because I'm no employment law specialist, it's also really important when you are considering the success of a due diligence process, if you are looking at doing a capital raise this year or you're looking to undertake a liquidity event of any sort. These are the kinds of things that your investors or your third-party purchaser are going to look into. they will look for your key employment contracts and they will be checking for compliance, and they may even be requiring you to update them as part of that process. So it's a really worthwhile process to go through. Now, you can, of course, use your free legal vision consultation to speak to one of our employment team as well about those changes. So that ends the substantive side of the webinar. Now, we've deliberately kept it relatively short as we've had some really great engagement on the Q&A front. I want to give sufficient time to that. Before we kick into that, we do have a free publication available to people attending today. It's our New Zealand Startup Manual. Now, this is a really helpful document that kind of goes into each of the topics that we've just discussed at a high level, and it will help trigger some thinking in terms of what you might need to revisit as you refresh your business operations going into the year. So you can download that from the handout panel. Now, set out below now are the details of that upcoming webinar that I touched on earlier. So that's around understanding your business's new employment law obligations. And that will be held on Tuesday, 5 March. And you can register on the link showing on your slides now. So well worth joining that one as well. Now, before we jump into the Q&A portion of the webinar, we'll just take a minute to tell you about LegalVision's membership. And I know that this is relevant to some of the questions that have come in today in terms of what can LegalVision assist with in the context of running a startup business in New Zealand. So by becoming a member, your business will get unlimited access to our full team of specialist lawyers for all of your business's usual legal needs. So it's like, we like to think it's like having your own in-house counsel for a fraction of the usual cost. And we also, on top of that, can offer a dedicated service for in-house teams and general counsel to help manage their high volume business as usual legal tasks, if that's also of interest. Now, to learn more about how that membership can help you, you can request that free consultation when the survey appears at the end of this webinar, and we do encourage you to make the most of that. You'll get a lot of value out of it, we're sure. So now moving to the Q&A. So I'll try and sensibly work through the volume that we've received, which is really, really great to see. The first question that I'm going to start us off with is quite a broad question, but I believe it will touch on quite a few questions that have been submitted. So we've had a question around what should my client contracts focus on, and can you please advise on important clauses for supply contracts for our larger customers? So in terms of your base supplier contracts that you're setting up for your business going forwards, the key pieces that we will look into if we are reviewing that for you or if we're preparing that for you are firstly the key commercial terms. So when I talk about that, I'm talking about, who are the parties? Are they clearly defined? What's the pricing mechanics that need to apply, and is that clearly reflected? What's the scope of work? Is that clear? What are the delivery terms, and what term does it cover? How does that agreement get terminated? So those are sort of the first pieces to get right, to check that it reflects the commercial understanding between the two parties. And then in terms of what we would look to build into a template supplier agreement that you could roll out from a business perspective going forwards, the key pieces that we're looking at are your IP protections. So Tayler obviously touched on that earlier. We're looking at who owns pre-existing IP and who owns the IP that gets developed during the course of undertaking the obligations under the supply agreement. Really, really critical. The second piece is your confidentiality obligations. Obviously some information sharing going on during the course of that relationship, and that's again important to protect and enforce certain confidentiality obligations on your suppliers. Insurance. What insurance does your supplier need to have, if any, and what level of insurance? And then the final piece, which a lawyer's haven, we're talking about the warranties, the guarantees, and the indemnities. So If you are a supplier, you'll be likely, or you're requiring your suppliers to warrant certain fitness for purpose, the quality of the services that they're providing, and things like that. And the lawyer will work with you to work out whether the scope of those warranties given are adequate, whether they're fair, and particularly if there are any warranty limitations that are being applied by the supplier, that those are fair and market standard limitations as well. So we'll help limit the scope of those limitations to protect the business's interests going forwards. Cool. The next question we have, I think Tayler, this one would be for you. So the question here, there's sort of two that we can combine here together. So I've been using a business name and logo for a while, but haven't trademarked it. Is that worth doing? And then the second question is a question around, what are the time and costs involved in obtaining a trademark?
Mhm. So your business name and logo are certainly valuable intellectual property assets for your business due to the effort that you've invested in them, the brand recognition, and the customer loyalty that they generate. So the best way to protect your business name and logo is to trademark them. And once you've done this, you can dictate how others may use your trademark and may pursue legal action against those who do so against your wishes. This offers legal protection to deter others from trying to imitate your business and benefit from the brand loyalty that you've generated. However, where you have been operating for an extended period of time and you don't have a trademark in place, to the extent where your name and logo has a reputation and is easily identifiable by customers, you may have other legal protections available to you. So you may have what is known as an unregistered trademark or be otherwise protected by copyright law. However, a trademark is certainly the most effective in offering the most enforceable protections. So it's best to book in a complimentary legal consultation with us to discuss your circumstances and the protections available to you, and well as to discuss how long the process will take and the costs involved, as this will vary about on how many trademarks you are issuing and the extent of those trademarks.
Yeah, and I totally agree. And I think the key there as well is starting that process early. The actual process to get the trademark registered is actually can be quite extensive, particularly if you're looking for worldwide protection. So it can take a long time. But typically what you'll find is you are protected from day dot of your application for registration if it does go through. So the sooner you start the process, the better protected that you are, assuming it does all go through. But yeah, getting sort of specialist advice around that is always key. And that also goes to that the business structuring kind of comments that I made earlier on in the webinar. If your IP is particularly critical, particularly valuable to your business, that's where you might want to be thinking about that dual company structure, and your holding company would be the company that makes the applications for registration and owns that trademark going forwards. And again, that protects you from those trading liabilities sitting at operating company level. So it does all sort of link together nicely. Okay, the next question we've got is an interesting one. It's, do you think the current economic climate is suitable for startups? It's a big question, and I'm not entirely sure how to tackle that, other than, I think when we're looking at, is the climate right for a successful startup? The typical things that we find our clients are interested in is, availability of capital. Now, we are in an environment now where raising capital is a little bit harder. That's a little bit slower than it was, say, 3 or 4 years ago when we were seeing really frothy valuations. The general sentiment is that that environment was unsustainable, unlikely to continue, and we're effectively just rebalancing. In a rebalancing phase at the moment. The reality is there are still VCs, there's still PEs out there with funds to deploy. So if you're a good business that's proving to have a lot of promise, then there is still an ability to access capital. We are seeing slightly friendlier investor terms to those capital raises. But again, we can help navigate you through what is sort of market standard given the current climate and what's not. And sort of, that's, I guess, where the guidance is really critical, whether it's a lawyer or some other advisor. They can help guide you through, whether the investors are trying it on or whether they are simply reasonable investor protections, which you are to expect. So I guess that goes to one part of that question, or what I'm anticipating the question is going to. The other part is, market demand and competitive landscape. So, very much depends on what your business is doing, where it's targeted, what its competitors are. What you often find is that an economic downturn can create new opportunities. Behaviours change, some businesses don't survive, all of those sorts of things. So that can create great opportunity. And then sort of the final piece to that is obviously cost of doing business. And typically here, our clients are looking at cost of labour, cost of rent, and they are high at the moment, is just a reality. Access to talent as well is particularly tricky because, again, living costs are meaning that we're losing a lot of talent overseas. And so retention is an issue, as well as attracting good employees. And so that's where businesses need to start getting a bit more creative. And we find this in the startup space anyway, where startups typically can't offer necessarily market competitive salaries. And so they do need to get creative in terms of, well, how do I attract the best people for these roles? And that's where we turn to, well, is an option plan, an ESOP, or some sort of equity allocation the right way to incentivize people when we don't necessarily have the cash available. Now, caution being is often the sentiment that we find is, ESOPs are too hard to navigate. We're not really that familiar with them. Now, they can be complex, but they don't have to be. So there's many levers that you can pull. You can make them as simple as you like, and they can be an incredibly effective tool for dealing with retention issues and access to talent. So definitely something that's worth considering. They're becoming more and more popular in the New Zealand market for all these reasons. Great. The next question, Tayler, I'll hand this one to you as well. So it says, I have suppliers who are based overseas. Which country's laws should apply to our arrangement?
This is a really important commercial decision that comes up a lot in cross-jurisdiction contracts. So all contracts will have what's called a governing law clause, and this clause sets out the country whose laws will govern the arrangement. So, for example, if you enter into an agreement which is governed by Australian law, this means that the terms of the agreement will be interpreted in accordance with the laws of Australia. It is certainly always our preference for entities operating in New Zealand to enter into agreements governed by New Zealand law. This is because there is a risk that where you enter into agreement governed by another country's laws, the agreement will be interpreted differently than they would be by a New Zealand court, and the terms of the agreement could also be ruled as invalid by the other court, meaning you would be unable to rely on such terms within the agreement. The other disadvantage that you can have is that if you ever enter into a legal disagreement, the claim will be heard by the overseas court, and this obviously increases your legal costs as you would be required to engage a local lawyer in that jurisdiction. So as I said, while it's always in your best interest for agreements that you enter into to be governed by New Zealand law, it is a commercial decision based on your appetite for risk and the importance of the contract to your business, as well as the bargaining power that you hold. If you are concerned about the risk of entering into agreement which is governed by another country's law, we strongly recommend you engage a lawyer based in that country to advise you further.
Yeah, cool. Great. Thanks, Tayler. We've had a few structuring questions. One, I'll try and sort of collate a few of them together. So the first question is, should I structure my business as a company or a partnership? Which one's more secure and easy to operate if the business has 3 partners? So in terms of the startup landscape in New Zealand, business landscape in New Zealand, we predominantly see people using the limited liability company rather than a partnership structure. The reason being multiple reasons. Key one being it's a very straightforward structure to set up. It's relatively cheap to incorporate a company on the Companies Office website, but more importantly, it's elegant and simple to use. So if you've got 3 partners, if you've got 10 partners, you're all running the business together. It's a great way of sharing ownership of your business and sharing ownership in a way that isn't just isn't equal ownership. So you might get a 10% shareholder. 80%, no, 70% shareholder and 20% shareholder. So you can easily split up proportionate ownership, and it's also very easy to introduce new shareholders, and also allows an easy way to exit from those arrangements. The partnership structure is slightly different in terms of the actual legal entity side of it, as well as the documentation that sits behind it. Less easy to change, albeit it can absolutely be changed. But I think probably in the space that I know that a lot of our viewers today are in, where it's a startup business, you're looking for strong growth, quick growth, and ultimately aiming towards an exit. The company structure is by far, typically seen as the much more preferable, much easier to use structure. The other piece to it as well is that in a business sense, when you're working with contractors and suppliers, people are used to engaging with companies. They like the fact that they can find you on the Companies Office website. They understand the structure, and they understand how they are going to engage with you going forwards. So that sort of hopefully answers that question. Obviously very situational dependent, and there may well be situations where a partnership is a much better structure for you, and so that basically goes down to having those initial discussions with your business owners and working out which is best suited for you and your particular business plans and growth plans. Now, going to the growth side of it, we've also had a question around what's the best structure to set up an entity in the US. Now, that does come up relatively regularly for New Zealand startups that are going global. The US is obviously a very attractive, very large market to launch into. Typically, we'll find that our clients will launch into Australia first as almost a bit of a test market, and then they'll go beyond there. But the US is particularly attractive. Now, what we find here is that usually the need to set up a legal presence in the US is driven by a lead investor. So normally it will be a situation where you're undergoing a capital raise, your lead investor is based in the US, and they will often require you to do what we call a US flip, which effectively brings your holding company up into the US. Now, that is something that is absolutely, I hesitate to say standard, but it does happen. It doesn't have to. So if that's not something that you want to be doing, you are you can always push back on your investors, and we still see US investors investing directly into a New Zealand company. The critical piece there is looping in tax advisors to work with your legal advisors to seamlessly work with you on what that restructure looks like, because often in that situation what we'll find is that IP doesn't actually get shifted up into the holding company in the US, and so it does sort of change the reasoning behind what we've spoken about before in terms of protection of your key assets, and sometimes it does mean that you end up with a slightly more complex structure where you effectively have your dual company structure in New Zealand and then a US company superimposed on top. Again, very situational dependent, not something to be particularly afraid of if that's what your investor is trying to socialize with you, but definitely get that advice and get that advice early, because it can slow down the process, particularly if you're looking to raise capital quickly. Cool. The next question I've got here is, what are my legal considerations when hiring New Zealand staff? Again, with this, the first sort of place that we go to with our clients is working through that distinction between employees and contractors. Very different rules will apply depending on what the actual situation is. And what you want to avoid is putting in place a contractor agreement when really the true relationship is that of an employment relationship, because the law will typically hold you to the employment law rules, regardless of what their underlying documentation looks like. So the first place that we go to is what does that relationship actually look like in practice? Then we look to the documentation. So does the documentation that's in place reflect the actual arrangements? And in that documentation, we go into the same critical points that we talked about with the supply agreement. So are key IP protections built in, and are there sufficient confidentiality protections in there? And the other thing when we're talking about employees and contractors, restraints of trade. So if it's a really critical key employee, and they are helping you build some really important IP, whatever that might look like, then you want to make sure that you have appropriate enforceable restraints in place so that they can't set up in competition, either during or after employment with you. The next piece to be thinking about there is obviously understanding your New Zealand employment law obligations, and so much of that will be making sure that you've got the right policies and processes in place, and you understand what you have to do as an employer, and then finally understanding your tax obligations, reporting obligations as well, and that's something that your accountant can help guide you through as well. Perfect. So look, we are unfortunately running out of time, and I think we definitely haven't got through all the variety of questions that were received today. So look, if we haven't managed to get to your question, I've got one final one that I'm keen to close off on, but if we haven't managed to get to your questions, please do reach out. We'll have a consultation with you. We can answer that question on the call and then work out, whether you do need further support. So do reach out to us. The final sort of 3 questions that we've got that are all that I'm keen to answer, that are all relevant to the webinar, is around, so we've got, is there a package of documents that startups can access to ensure that they've got everything covered to start a new business? I'm new to running my own business. What aspects can LegalVision help with? And then also, what actions do I need to take in order to make sure that my business is operating legally? So lots of questions there. They kind of all go to the same points. What we would typically do from a legal perspective when we're really starting out at the outset with some of those really broad questions around legal compliance and setup is that firstly, we would look at business structure, make sure that we've got that set up correctly. Next, you're looking at your internal facing relationships, so employment contracts, shareholders agreements, things like that. Then you're needing to look at your external facing relationships. So, have you got your privacy policy covered, website terms of use up? Have you got documents that deal with your key relationships with suppliers and suppliers and customers? And what we typically recommend you do is that you set up template documentation, particularly on the supplier and contractor front, that works for you and your business and protects your interests. And then you're in a position where you can table that immediately when you're having those initial negotiations, and you basically front foot the negotiations on those documents. And it makes your life in terms of running the business a lot more straightforward, having the comfort that that documentation has been prepared for your business and it's fit for purpose. Now, swinging back then, how does LegalVision help? So that startup manual, I really encourage you to download that. It covers all of the stuff that we've spoken about today. It answers some of the questions that we haven't managed to get to today, and it will help start trigger some of that thinking around, do I have everything in place that I need? And obviously LegalVision can support you with any areas that there might be gaps in on that front. So it's a lot. And look, thank you all for your time today. After the webinar ends, as Taylor noted earlier, a survey will pop up, and we'd really appreciate it if you could complete that for us. And in that, you can include your contact details to get that legal consultation, and we can help you a little bit further with your business needs for 2024 and beyond. So thank you so much for joining us. Thank you, Taylor, and we look forward to seeing you all at one of our webinars next month.
Thank you, everyone.